More issues with executive orders from President Trump affecting federal employees. Folks, this is really critical that you watch these podcasts and that you pick up and absorb the new information. These rules are changing as fast as lightning here. And there are some developments in the last few months which are so critical that federal employees really do have to stay on top of exactly what's going on in the federal government. Well, I'll tell you what's going on in the federal government. I don't think it's any grand surprise here as of September 2018 is that a lot of jobs are being eliminated. It may not happen all at once, but in terms of shrinking departments, in terms of even President Trump deciding to get rid of entire agencies, which seems to be part of the plan at least. As I've said in one of my other podcasts, the president has made it easier to terminate federal employees now, reducing the performance improvement plan time in many cases to as few as 30 days. But there are two more really important developments. One of them is in the executive order promoting accountability and streamlining removal procedures consistent with Merit Systems principles. And this has to do with Section 5, ensuring integrity of personnel files. And it says, agencies shall not agree to erase, remove, alter, or withhold from another agency any information about civilian employees' performance or conduct in the employee's official personnel records, including an employee's official personnel folder and employee performance file, as part of or as a condition to resolving a formal or informal complaint by the employee or settling an administrative challenge to an adverse personnel action. Well, what does that mean? Well, in short, that means that employees that are disciplined or terminated who want as a settlement condition what is known as a clean record, forget it. Agencies can't do that anymore. So you take a typical case of someone who was terminated for cause. This happens at the Merit Systems Protection Board, used to anyway, all the time. Whatever it was, person borrowed a government vehicle 14 times and ran up all kinds of credit card debt that the person didn't pay on a government credit card. And then they come to my office. And what can I do for them? Well, used to be very little. Except for the all-important, if you're really guilty, meaning this, if I've looked through your file and it really, really looks like you did these things, okay, I'm not going to lie to you and tell you that, this is just, they're going to blow this off. No, you will get fired, but what we can do is if there's any semblance of a case here for you, meaning if there's any chance you can get generally a clean record, in which case the government will remove all this bad stuff from your file and no one will ever be the wiser. And a lot of these SFs, 50s will simply say that you left for personal reasons. Not anymore. And that is really, really important. So what does that mean? What that means is more people are going to have to litigate the removal of things like suspensions from their records. Because there's no, even if the agency wanted to change your file and not pay you anything, just simply give you a clean record, they can't do it anymore. That is a really, really big development. And what that also is going to do is raise the value of settlement agreements. Because once the employee cannot get rid of the suspension or the termination that's on there, the employee literally has no choice but to go to hearing on this thing, unless the agency is going to pay this employee enough not to do that. That is a really, really important development, along with another one, which is the executive order accepting administrative law judges at the Merit Systems Protection Board from competitive service. What does that mean? Well, recently I had a mediation with a federal employee and a federal administrative law judge from the MSPB, and I asked this judge, what does that mean in terms of effect on the Merit Systems Protection Board hearing process? She explained it very well. She was very honest about it. Is that under competitive service, the admin judges have a level of protection, just like any other federal employee, from termination. So the admin judge can't be terminated unless the performance really warrants that. Well, not anymore. Once you take away the competitive service element, what happens now is that person can be removed a lot faster and a lot easier. So what does that mean? Well, an admin judge who loses her independence to the agencies, okay, which is what this is, because these people now understand if they rule too many times for the federal employee and against the agencies, they could be terminated. So, not that the MSPB was easy to start with, but it's not getting any easier. And now you're going to have this additional layer here of is this administrative judge going to be independent? And this is one of the problems with the EEOC administrative judge system, is that a lot of people have complained about this, is that there's no congressional oversight over this. These people essentially are beholden to the agencies, which is why it's no secret. I've tell many of my clients that my preference is federal court, where you have you don't have administrative judges. You have real judges. You have people who went through the entire Brett Kavanaugh process. May not have been to the level of that. There wasn't committee hearings for each of these people that are broadcast on C-SPAN and all kinds of protesters and so on and so forth. But those people are appointed for life. So here's the bottom line that I tell my clients and followers of these podcasts. There's not a lot that has really changed in terms of my whistleblower practice, even with all these developments, because at the end of the day, I've always said, to win at the MSPB, or to even get a settlement at the MSPB, which for the most part is a win, the government is only going to settle if they think they're going to lose. You need good facts in your case. You need a really good case. If you have really good facts in your case, and you have the right lawyer to assemble those facts into a coherent story that makes a lot of sense and is compelling, your chances of getting a settlement is really good. If you don't, and you're just one of these people, I love telling this story. I had once a guy who was, he came in for a consult. He was worked for Social Security Administration, and he paid me a consultation, hour-long, $425, to review his case. He had lost at the Merit Systems Protection Board, and I read the opinion, and he told me he had a union rep at the hearing representing him. And I said, well, it looks to me like you admitted on cross-examination that you sold Social Security numbers to this income tax preparer so that his clients could claim additional deductions, and then you got a fee for doing that. So am I missing something here? So did your lawyer just blow that? I mean, did that just not happen and you weren't vocal about it? Or tell me why this case is on appeal. Was that what happened? So he said to me, no, my lawyer was fine. That really happened. So I said, so if you sold Social Security numbers and got fired for doing that, so what's your case? So the guy confessed to me. He says, well, I was just kind of figuring to see if I could get anything out of this. So I explained to the guy, no, you can't. If you're really against paying higher taxes, and you know people that are, you should join an organization called Americans for Tax Reform. It's a lobbyist group down on M Street. But your problem is not solved through the legal process. So, I mean, you have people like that. And at the end of the day, obviously, you want to be in the category of cases where you are performing well, where there are good facts, and you want to keep a written record of what you're doing at work, to make sure that you have yourself covered in any kind of claim of you're not doing your job. Because there's also going to be a lot of pressure on the agencies and agency lawyers to win the cases they've brought. Because if they don't, if the thing is obvious, in my view, the judge is still going to rule for the plaintiff, for the appellant. I think that in clear-cut cases, I don't think the loss of independence factor is going to change results. And I think that they'll blame the agencies, and the agencies will blame the lawyers who screwed it up, or the management officials who screwed it up. So the dynamics have not changed. The only thing that has changed is that there will be fewer cases that probably would have settled for a clean record that will not happen anymore. These are the real key developments that you have to keep watching these podcasts. You have to keep finding out what's going on, what's new in the law, what's changing. It's going to be this one MSPB judge had told me that there is a backlog there of these cases now. And she was almost at the point of despair, which also could be good in terms of cases where Merit Systems Protection Board judges just simply want to, they still are under that 120-day time limit or something reasonably close per the case, where they may want and push agencies into settlement to not have to deal with the gigantic backlog. But as you've looked through the stories here that are on this month's and the events that are on this month's newsletter, these cases, particularly the suspension one with the Merit Systems Protection Board, I mean, this was a clear violation, in my view, of this whistleblower's rights, and the agency had to settle. I think even with the loss of independence, they had to do what they had of this whistleblower's rights. And the agency had to settle. I think even with the loss of independence, they had to do what they had to do.